Reparations, for me and for all of us, is about justice. I was first asked to work on the issue back in the early 90s by the great Pan-Africanist Dudley Thompson. And I presented, as you heard, the paper on the legal basis of the claim for reparations. I won't go through those points again today, because we need to move on to the future, not just rehearse things you all know. You know that the transatlantic trade was the most heinous crime against humanity. You know that international law recognizes the right to reparation. And you know there is no statute of limitations. And you know that the descendants who continue to suffer are entitled to reparation from the state which carried out the crimes. Don't let anybody say it's too long ago. Look at the Maoris, a very strong, proud people from New Zealand, who secured a reparations settlement for crimes committed against their people in 1863. The Queen herself signed the reparations settlement bill into effect. But one thing I do want to dwell on, it is sometimes said by the British and other nations that in international law there is no claim because slavery was legal at the time. Don't buy into that one. It's a common excuse, but in fact the laws of all European nations were clear. In Britain, indeed, a law was passed in 1749 which provided that, quote, no commander of any ship trading to Africa shall by fraud, force or violence take on board or carry away from the coast of Africa any Negro or native of the said country, unquote. That was an English law. Chief Justice Holt, one may said, quote, one may be a villain or serf in England, but not a slave. By the common law, no man can have property in another. And in the famous Somerset case, Chief Justice Mansfield ruled that the state of slavery was so odious that it could not be approved by the law of England, and therefore the black must be discharged. You see, they broke their own laws. So don't let them tell you that slavery was legal at the time. It was against their laws at the time, and the same thing was in France. There was a freedom principle in France which declared, quote, all persons are free in this kingdom. As soon as a slave has reached these frontiers and becomes baptized, he is free. And similar laws in Spain. And I acknowledge and recommend the work of Dr. Nora Whitman in her book Slavery Reparations, The Time Is Now, who has documented a huge array of sources to show that in the world as a whole, the trade in Africans and their enslavement in the Caribbean were crimes under international law at the time. As we've all been talking about, in any claim, the damage has to be proved. And here we come to the 10-point action plan. In the House of Lords debate in 1996, which you're going to see a snippet of in the film tonight, Lord Chesham, who spoke for the UK government, said, quote, the case for reparations for slavery rests on the premise that the effects of slavery are still being felt on Africans now living in Africa and the diaspora. There is no evidence of that. False. Lies. You know how wrong he is. But the corollary, listen to what he says, it will be repeated tonight. The corollary of what he says is, if there is proven evidence of the continuing effects of slavery on today's African peoples, then the case for reparations is made out. The 10-point action plan focuses on areas where it can be shown that the consequences of slavery are felt in the Caribbean. And it puts forward those areas as the bases of reparations claims. And this fits in with the concept of repairing the damage. Each point, however, will need to be backed up. This is why we are here. Each point will need to be backed up with evidence and research. And we've had contributions about public health, and we will have a contribution tomorrow about psychological rehabilitation. A lawyer, and I speak always, as both as a lawyer, wants to see the evidence, the proof. And we can't just take it for granted. Any claim will have to be supported by concrete evidence. The mechanisms for reparation. We're in a new phase. Not just making the case for reparations, but thinking about how reparation is to be made. What is the role of national governments? How do we secure accountability? Should there be some form of trusteeship or oversight involving civil society? Already I found in Jamaica there's a degree of cynicism being expressed about reparations being paid to corrupt governments and not to the suffering people. How do we involve the people in the decision making and ensure that they see the fruits? In my presentation in 1993, I said, quote, "Who should process the claim on behalf of so many? This is a matter which transcends national governments, but governments are the chief implementers of social programs, as well as being responsible for the repayment of their country's foreign debt. They should neither be excluded from, nor have sole control over, the prosecution of the claim," unquote. I believe that the growing number of national reparations committees is a good start to resolving these questions. Each country's committee needs to sponsor maximum popular consultation, both as to the needs and priorities for reparations and as to the mechanisms for accountability. And we come lastly to legal remedies. In previous cases where reparation has been made, for example from Germany to Israel, from the USA to Japanese Americans, there has been negotiation and campaigning, leading in the end to an agreement. This should be the prime goal. Reparation is a form of reconciliation and should if possible be secured through a negotiated settlement. But if all claims are rejected, is there any legal recourse? There is, in my opinion, no court of law in which the claim for reparations can be successfully presented. I say this because even though I know that there are cases pending against the French government in Martinique and Paris, and cases brought against corporations in the USA, and in Jamaica, my brother Miguel Lorne brought an action against the Queen, which was, however, soon struck out. I believe these cases have important publicity and mobilization value, but it's not like an ordinary case in court. You won't just go to court and get a judgment. There are jurisdictional problems about taking a case to the International Court of Justice or to the International Criminal Court. In the case of the International Court of Justice, the British government has made a reservation. It accepted jurisdiction only over all disputes arising after 1974, and then not with Commonwealth governments. So a dispute with a Commonwealth government can't be entertained by the International Court, as far as Britain is concerned. It could, however, be possible to obtain an advisory opinion from the International Court of Justice, which, although it does not result in any binding judgment, could have immense authority and persuasive force. The General Assembly, or the Security Council, but we're talking about the General Assembly here, quote, "may request the ICJ to give an advisory opinion on any legal question." Of course, a sustained campaign within the UN, as it was talked about earlier today, a sustained campaign within the United Nations would be needed to persuade a majority of the members of the General Assembly to support such a request. Now we come to the slightly different route, which has been suggested by my brother Martin Day in the lead legal brief, and that is that the CARICOM governments should make a complaint under the Convention on the Elimination of All Forms of Racial Discrimination. Now, under that convention, state parties must take effective action, effective measures, to review governmental, national and local policies, and to amend, rescind or nullify laws and regulations which have the effect of perpetuating racial discrimination wherever it exists. The argument is that the policies of the United Kingdom and other countries, in not apologizing for and making reparation for the transatlantic trade and the institution of chattel slavery, have perpetuated racial discrimination and racial disadvantage in CARICOM nations, and those policies must therefore be changed. If there is no satisfactory settlement by negotiation, a dispute under this convention may be taken for resolution to the International Court of Justice. Now, I've thought long and hard about this approach. At first I thought it wasn't really a reparations claim, but a claim to say, well, you haven't been helping us enough. However, after a number of conversations here and before, I'm persuaded that we can make this into a reparations claim. The eloquence that comes from this conference alone, the imaginative eloquence of our speakers today, persuades me that however you dress it up, under whatever convention you bring it, this is a reparations claim. For example, why are people racially discriminated against, racially disadvantaged in the Caribbean nations? Because of the crimes against humanity committed by the British and other nations. So that if you are to repair that damage, and you are to end those forms of discrimination and disadvantage, then you are making a reparations claim. And so I have to some extent revised my view and think that it is possible, with proper presentation, with dynamic presentation, with popular support, and with a tremendously mobilized government and peoples behind it, this can be the focus. Not of a panacea to end the whole question, but a step along the way. It is a long road. I know my other country of citizenship, the United Kingdom. They're not going to like it. They're not going to like being brought to the negotiating table. They don't like the reparations issue at all. In fact, their role in so far as reparations is concerned is quite sinister. But if we are strong, if we are mobilized, if our governments stand with our people, we can and will, as so many people have said today, we can prevail. Venceremos.
We're going to take Mr. Jodell's now, and then we'll come back to we'll take all of the questions together. Jodell's is... I'm sorry. I'm saying we're gonna wait for the questions and take both panelists, and then have an open forum where we will entertain your questions. That was Anthony Gifford, Lord Anthony Gifford, presenting quite passionately about what needs to be done. We will now hear from Mr. Jodell. Jodell is an attorney, a lawyer in St. Vincent and the Grenadines, and he is a member of the St. Vincent and the Grenadines Reparations Committee. Jodell.
Thank you very much, Mr. Chair, and good afternoon to everyone. I hope everyone is doing well after a very long day. I will try to be brief and to the point. I received a request to give my reaction to the 10-point plan. The topic was a little bit nebulous, slightly vague. But when I looked at the 10-point plan, I became stuck on the very first point, apology. I was very happy to hear my other sister from Trinidad speak on the issue of apology, because contrary to some of you, I think an apology is absolutely critical to the reparatory exercise. In the 10-point plan, it states reparations seeks reconciliation between victims and beneficiaries. As such, it is non-confrontational and conciliatory. Reparations seeks to restore equity in social relations, equality before the law, and justice within the fabric of human diversity that typifies humanity. Reparations seek to heal, atone, and bring closure to the human tragedy and slavery, of mass slavery. It seeks, finally, to restore a higher moral order by removing the shame and guilt that persistently poison the relations between descendants on both sides of the crime. So clearly, by this definition, reparative justice falls at the intersection of morals, ethics, law, and of course history. We're really talking about the fundamental areas and aspects of legal jurisprudence. Now, notwithstanding that a lot of people, at least in St. Vincent, don't think that reparations are important. They say, well, where are you going with that? We ain't want no apology, boy, we want... Right? I repeat that reparations must include an apology. And that it is critical to the entire reparations exercise. But the 10-point plan speaks about an explicit formal apology. But we need to be clear on what that means. It can mean a variety of things. And of course, the first thing that comes to mind, as Dr. Shepard has mentioned, is, do all of the 10 points, are they joint and several, as the lawyers love to say? Do they include one another, or is it just individual? It seems to me that we want all of them. and we will take them individually if we get them individually. Now, you can get an apology in many forms. An apology can acknowledge the suffering by others without more. So for example, you could tell somebody whose relative has died, I am sorry for your loss. Right? An apology can express regret or solidarity for things outside of your control. So for example, I am sorry you had such a hard time with the immigration officials in coming into Antigua. And you can say an apology can be an acceptance of fault as a precursor to redress. So for example, sorry, I crashed your car. Now in the domestic law, in a simple car accident in St. Vincent and Grenadines, what very often happens, two people run into one another, they write down something. And that sticks up in a court of law in terms of liability. So I would say that it's only in the latter incident that an apology would carry legal implications and establish liability, which I think is what the 10-point plan is trying to get to. But I want to make a suggestion that is going to be controversial. I'll make that suggestion or posit that issue at the end. Now, obviously, as the doctor from Trinidad mentioned, if the apology is not sincere or lacking in meaning, it obviously will exacerbate things rather than soothe things. So all of that has to be included in what the 10-point plan really means by an explicit formal apology. Probably means a full, unreserved apology. Now, very interestingly, you can have legislation that encourages apologizing. There is such legislation in the province of British Columbia. And when it first came up, the ombudsman who raised it in a paper called The Power of an Apology, Removing Legal Barriers, he said that when a person feels aggrieved, having someone apologize for what happens enable the person to forgive, to re-establish the relationship and to move forward. So the BC government passed the Apology Act back in 2006. And it allows apologies, but it expressly states that it is not an admission of liability. Right? It doesn't confirm a cause of action for the purposes of limitation and so forth. It doesn't affect your insurance, and it is not admissible in civil proceedings. And it have at least one other province in Canada that has followed suit. So the question I'm going to come to is, should we go a route like that? Let me just elaborate. There have been a lot of recent apologies by colonial governments and occupying powers. And I'm talking about national governments as opposed to provincial governments or the governments of cities. So in Australia, 2008, Australia apologized for the policy known as the Stolen Generation. We know all about that. In 2000, September 8th, the US government apologized to Native Americans for the so-called clearing of the Western tribes, basically the massacre. Well, we had a church apologize to Native Americans, but they're not a government. The US government in Hawaii, the US government apologized to the people of Hawaii in 1993, exactly 100 years after they conquered the Kingdom of Hawaii. This was an interesting move. They passed the Apology Bill, which stated that the people of Hawaii did not surrender their sovereignty or land to the US, either through the monarch or through a plebiscite or referendum. And Congress committed itself to acknowledging the effects of overthrowing the kingdom. Now, as we know, the British government through Queen Elizabeth II apologized to the Maori people, and they received $40 million in compensation for the land that was seized by Britain. In 1997, the King of Norway apologized to the Sami people, which was an indigenous people in that part of Europe, for the policy of assimilation. And in 1999, Denmark apologized to the Inuit people who were displaced from Greenland in the 1950s. Canada apologized many times to several different groups. They apologized to Japanese Canadians who were interred during World War II. And of course, they paid them $300 million. Canada, yes, to Japanese Canadians, yes. And they also apologized to the so-called head tax, which was a discriminatory practice that Canada inflicted on Chinese immigrants. So those are some examples of apologies by national governments. Now, the 10-point plan is replete with calls for Europe to take responsibility, quote, take responsibility. It cites that the British state is the custodian of the wealth and conscience of British society. Now, the question I have in my mind is, why is it that these reasonable appeals to conscience, to equity, and so forth, which is really means conscience, why is it that these appeals are met with such stout resistance in the legal superstructure in Washington and Europe and so forth? In other words, where is the equity, if you were to use a domestic phrase, a domestic law phrase? We all know, and it's been mentioned here today, that there's a US congressman who has been trying to get Congress to study US slavery and its effect for decades. The bill was called H.R. 40, and it would have commissioned the study of reparations for African Americans in 25 years. Is it 25 years? Yeah. It's about that, since 1969?
89.
89, sorry. It's never gotten off the ground, right? Now, Mr. Coates, whom everyone has mentioned, and that article needs to be read, just in June this year, he thinks that the reason is not the impracticability of reparations, because a lot of us are getting stuck with the details and what another speaker mentioned, the impossibility of it. It's not impossible. But Coates is saying, look, the real reason is not the impracticability. The real reason is more existential. That's his word. He says reparations makes the US look bad. He concludes by saying that reparations would represent America's maturation out of the childhood myth of its innocence into wisdom worthy of its founders. Okay? Now, this was an interesting argument. And there is an article by Professor David Williams, who is a professor of law at Indiana University School of Law. His article is called "In Praise of Guilt, How the Yearning for Moral Purity Blocks Reparations for Native Americans." He was writing on Native Americans, but it's very relevant, both because same issues, and also because in St. Vincent and Grenadines, a lot of what he's writing about what happened to the Native Americans happened to our Garifuna people. And in that article, he posits, as a lawyer, that guilt and the release from guilt is critical to the success of reparations. His argument is that the US perceives itself as a nation created via consent of its people, but it was created really and truly by conquest. The effects of this fiction on the legal system, he says, is this, and this is the quote: US judges feel that they must not only recognize the conquest as a brute fact of history, they must also develop an account that will make the conquest seem legitimate. Otherwise, because their own power arrives from conquest, they would be forced to declare themselves illegitimate. So they must find or make a serviceable myth of origin. He says, when American Indians seek collective reparations, they deeply problematize this myth-making. Claims do not merely suggest that the US has violated its own laws and so must make its victim whole. They suggest that the US had no right to extend its jurisdiction over North America. Right? And he concludes, if purity is no longer an option, then guilt is no longer unbearable, and the US should unload the guilt. Now, his analysis is showing a country and a system that is not just committing misdeeds from time to time, but rotten at the root. And we lawyers like to speak about jurisdiction, because that's the start. If you have no jurisdiction, everything that follows is void ab initio. Now, the call for reparatory justice threatens the historical fiction of, in our case, a British legal superstructure that is morally pure. It's a fiction. Reparations cast aspersions on Britain's right to the moral and therefore legal high ground. The legal thrust must attack the legal infrastructure at the foundation, because you're going to meet a lot of arguments, for example, the limitation argument and so forth. But lawyers are very creative, and part of my argument is that the legal infrastructure was created by these powers to meet and promote and protect their interests. We have to find legal arguments, whether it's within their own legal superstructure or outside, and I'm suggesting that a lot of these answers are in the court of public opinion. The court of public opinion. Now, how much time do I have, sir? Am I all right? Okay. All right. The British legal fiction and Garifuna land. The British fashioned a legal structure for their relations with our indigenous people, the Garifuna. The false legal fiction was that their intentions for the land was peaceful. The second was that the land transactions were consistent with voluntary dealings done, like we like to say, at arm's length between equal partners. They never considered the people they met there as their equals. And in any event, the Garifuna never sold the land. The British further viewed the taking of the land as legitimate because of the character of the relationship the Garifuna had with the land. The Garifuna and the other peoples who were there, whom they met there, did not see themselves as owning the land in the same way that the British did. So as Professor Torres, who is at the Law School of University of Texas, his article is called Indigenous People, Afro-Indigenous People and Reparations. He said, arguments for ownership came from the concept that the drive of the settlers gave right to arise, and thus the concept of the agricultural estate became synonymous with the colonial settlement. So this is ratified in the Lockean, this is ratified in practice, the Lockean idea of claiming legal significance for the fact of clearing and planting. He adds, the local people were not planters, so they failed even the Lockean test of ownership claims. And the extent that they failed in that essential relationship, they failed in their obligation to be considered as men. So it then became easy to exclude these people whom they met there from the civil society and all the consequential rights, including the claims to the land. Okay, I'm told to wrap it up. I just want to point out two things. Collective ownership of indigenous land, even where you have no paper title, is now being recognized in international law. Okay, there's two cases that I mentioned, one from Suriname, and the leading case is from Nicaragua. But those persons, those indigenous persons in those countries sued the government, their government. We're speaking about suing the colonial government. So there are several differences there. I'm not sure what the differences are, because unfortunately I am not yet an international law practitioner, not yet. Finally, in view of what I've said about how the 10-point plan starts out, about reparatory justice conciliation, and in view of what the CRC's strategic operational plan says, that British fears that proliferation of claims against the British government, the British are afraid of claims and claims and claims against the British government, the Crown and financial institution. And the CRC says these should be sensitively confronted. Sensitively confronted. So I pose the question to this committee, and I don't want all to kill me with this question, or for this question, because my own colleagues, it's controversial. Should we assess Britain, this is a question, should we assess Britain to unload its guilt by encouraging an apology which is complete, full, and unreserved, but with no legal consequences? If such a vehicle was available to the British, and they refused the opportunity, then Caribbean people, and indeed the whole world, will know that they are not truly sorry. for these crimes that were always crimes, whereupon we would move on as before. We have the other items that we're going to tack anyway. We'd have lost nothing. But if they accept the offer and they do apologize, would that unloading not make restitution that much easier? Thank you.
Thank you very much. Thank you very much, Joe Dance. Thank you very much, Lord.